The joint meeting of the Senate and Assembly Public Safety Committees to continue our informational hearing on the initiatives relating to the death penalty that we believe will may be on the November ballot. We are taking no action today. We're simply collecting information to further the public's knowledge of the initiatives before the voters. I want to thank all of you who were here this morning for being here again, those of you who are here for the first time. As I think we all know, these ballot initiatives address a very serious and complex public policy issues and ethical issues and financial issues. The assistance of all of you today in laying out the provisions of the initiative are deeply appreciated. And we look forward again to a constructive conversation that will help prepare all of us in California for the important decisions that lie ahead.
Thank you. I'll just quickly say good afternoon and welcome to the hearing on the initiative to reform the death penalty, the Death Penalty Reform and Savings Act of 2016. As many of you know, in 2013, Senator Anderson had a bill that was substantially similar in many aspects to this proposed initiative. So some of the aspects of the initiative may be familiar to some of the committee members. As far as procedure for the hearing, the format obviously will be the same as this morning. We'll hear fiscal analysis from the Legislative Analyst's Office, followed by testimony from both sides, and finally public comments. So I just want to, again, I recognize that the death penalty is a divisive and often an emotional issue, and I remind everyone to be very respectful of divergent views. And I guess with that, we will invite our first panel to come up.
We will. Anita Lee from the Legislative Analyst's Office and Drew Soderberg from that office. Welcome again.
Good afternoon, members. The sergeants have distributed a second handout, not to be confused with this morning's, that we will be using as a guide for our conversation this afternoon. If you turn to page 1 of the handout, we're not going to go over it again. It's going to look really familiar to you. It's an overview of the LAO's role in the process. The only thing that we will say is, just as a reminder, that we are currently in that second step where we are going through the process of preparing materials for the ballot. If you turn to page 2 of the handout, we then begin to provide some background that is relevant to this initiative. The first section we'll skip over. It's there for your reference. It is a section that provides a little bit of background on when the death penalty can be sought. The second section is new, and it focuses on legal challenges to the death sentences. And so upon conclusion of a murder trial, defendants who are found guilty and receive a sentence of death are entitled to a series of legal challenges, and they really fall into 2 areas. The first are direct appeals. Under existing state law, direct appeals, or arguments that violations of state law or federal constitutional law took place during the trial, are automatically appealed to the California Supreme Court. These appeals focus on the records of all of the court proceedings that took place that resulted in the death sentence. Second, we have habeas corpus petitions. Habeas corpus petitions are legal challenges that involve factors of the case that would not be evident in the records that are being reviewed in the direct appeal. These include claims that the defendant's counsel was ineffective. And so these are first heard in the California Supreme Court and then the federal courts. If you turn to page 3 of your handout, as we mentioned previously, legal challenges to death sentences can take more than a couple of decades to complete in California. An estimated 337 direct appeals and 263 state habeas corpus petitions were pending in the California Supreme Court as of April 2016. The California Supreme Court appoints attorneys who meet qualifications established by Judicial Council to represent individuals who have been sentenced to death but cannot afford legal representation. Different attorneys are generally appointed for direct appeals and habeas corpus petitions. As of April 2016, 49 inmates were waiting for attorney appointment for their direct appeals, and 360 were waiting for attorney appointments in their habeas corpus petitions. The final section on this page contains some bullets related to the implementation of the death sentence, the first one being a breakdown of those 930 individuals who have received a death sentence since 1978. We will point your attention to the very last bullet in that section, which talks about the lethal injection protocol in the state. The state prisons generally use lethal injection to execute condemned inmates. In 2006, federal courts stopped executions after ruling that the state's lethal injection procedures were unconstitutional. Between 2007 and 2010, the state revised its execution regulations. However, state courts ruled that the state did not follow the Administrative Procedures Act, or APA, when revising its procedures. As a result, executions cannot resume until the state develops regulations in accordance to the APA. Draft regulations were subsequently published in November of 2015 and are currently undergoing public comment. Turning to page 4 of the handout, we look at the major provisions, and this initiative has a number of them. The first one relates to habeas corpus petition hearings. The measure requires that habeas corpus petitions first be heard in the trial courts instead of the California Supreme Court. These petitions would generally be assigned to the judge who presided over the original murder trial. Trial courts would be required to issue a statement explaining the basis for their ruling. This decision could then be appealed to the courts of appeal and then to the Supreme Court. Cases that are currently pending before the Supreme Court could be transferred to the trial courts. The second major area involves the imposition of time limits on the death penalty process. The measure requires that the direct appeal and the initial habeas corpus petition be completed within 5 years of the death sentence unless extraordinary and compelling reasons justify the delay. The measure requires that the initial habeas corpus petitions be filed with the trial courts within 1 year of attorney appointment. The trial courts would then have no more than 2 years to issue its decision. If a petition is not filed within this time period, the court must dismiss the petition unless it determines that the defendant is likely either innocent or ineligible for the death sentence.
Excuse me, could you just tell me where you are in the handout? You're talking so fast, I'm losing.
Oh, I'm sorry. We're
thread.
on page 4 in the second section.
Okay.
And we're now on the third bullet in that section.
Thank you.
And I will also slow down.
Thank you.
In order to help meet the timeframes that are proposed by the initiative, the measure also imposes various other limits. For example, the measure limits the number of additional habeas corpus petitions that may be filed. If you turn to page 5 of your handout, the next section that the initiative touches on is related to the appointment of attorneys. The measure directs the Judicial Council and the California Supreme Court to reevaluate and amend the attorney qualifications for death penalty legal challenges in order to expand the number of attorneys available for appointment to ensure cases are heard in a timely manner while ensuring competent representation. The measure also requires that certain Court of Appeal appellate attorneys be required to accept appointment to direct appeals under certain circumstances. For habeas corpus petitions, the measure shifts authority for appointing attorneys from the California Supreme Court to the trial courts. The final section involves some provisions that are unrelated to kind of the court appeals process, and there are really 3 in these areas. The first makes changes to the Habeas Corpus Resource Center, or HCRC, operations. It includes shifting oversight of the HCRC to the Supreme Court upon elimination of its board and limits HCRC legal activities. Second, the measure, similar to the one this morning, specifies that every person under a death sentence must work while in state prison and have their pay deducted if the inmate owes victim restitution, subject to state laws and regulations. Because the measure does not change current state regulations related to inmate work, existing practices would not necessarily be changed. The measure increases from 50% to 70% the amount that may be deducted from inmate wage and trust accounts if the inmate owes victim restitution. Finally, The measure exempts execution procedures from the APA and allows the housing of condemned inmates at any prison. The measure also makes various changes regarding the method of execution used by the state. For example, challenges to the method may only be heard in the court that imposed the death sentence, and the state must generally maintain a valid method of execution. Turning to page 6 of the handout, we shift our attention to the major fiscal effects. And we're first going to focus on the courts. And we will remind the committee that we are in the process of preparing ballot measures, and so we have received additional information from both the proponents and the opponents that we are considering. So in terms of the state courts, this measure would likely increase court workload and require significant staffing increases to address the hundreds of pending cases within the time limits required by the measure. The measure would also likely require a significant increase in the number of attorneys appointed to represent condemned individuals. This could require the recruitment and training of qualified attorneys. These costs are subject to considerable uncertainty and would depend on how this measure was interpreted and implemented. For example, the courts might determine that more than one attorney should be appointed to meet the measure's required timeframes. In total, the extent of the increase in state cost in the near term is unknown and would depend on how the courts addressed the increased workload, but could potentially be in the tens of millions of dollars annually in the near term. The fiscal impact of the measure in the longer run is less certain. On the one hand, to the extent the measure resulted in a reduction in the number of cases currently pending and the amount of time each case takes, the measure would eventually allow the state to reduce its expenditures on post-conviction proceedings. On the other hand, the state courts would need to maintain a certain level of staffing at all times to handle these death penalty cases. The measure could also result in a net long-term increase in the cost of these post-conviction proceedings under certain circumstances. For example, the additional layers of required review for habeas corpus petitions could add to the time and cost of each case. Moreover, if the measure resulted in the state appointing different attorneys for habeas corpus petitions before the trial courts and the courts of appeal, the cost of each case could also increase. Turning to the final page of your handout, page 7, we turn our attention to the state prisons. The measure could result in reduced state prison costs to the extent the state changes the way it houses condemned inmates. For example, if male inmates were transferred to other prisons instead of being housed in single cells at San Quentin, it could reduce housing and supervision costs. In addition, to the extent the measure resulted in additional executions that reduced the number of condemned inmates, prison costs could be further reduced. In total, this reduction in state prison costs could potentially reach the tens of millions of dollars annually. With that, we're happy to answer any questions you have.
Senator Monning.
Thank you, Madam Chair, and thanks again to the panel for your work on this. Just closing in on that final statement, there's uncertainty about potential expanded costs at the court level.
Yes.
And then you conclude by saying, in total, this reduction in state prison costs could potentially reach the tens of millions of dollars annually in reduction. Mm-hmm. Do you have any net assessment of this ballot measure as drafted with uncertainties, greater cost to taxpayer or savings to taxpayer?
In terms of, it's very difficult for us to do that, and I think part of it is on the court side, we have the near term and we have the long term. I think in the near term, we're, in our assessment, we do think that there will be an increase in costs. In the longer term, it's less certain. And so because of that, we did not feel comfortable doing a net overall cost for the state.
And presumably on the potential reduction, if more executions are carried out, presumably that savings is reduced costs of housing and mm-hmm. medical care, et cetera. But does it quantify the actual cost of performing an execution? Is that factored in terms of the cost to the state and the taxpayer to prepare, and carry out an execution?
So in terms of that, we are having conversations with CDCR, and so as I mentioned, we're in the process of taking in additional information. We have received additional information from stakeholders, that includes the courts and CDCR, as well as both the proponents and the opponents. And so we're in the process of kind of modifying our model. The original model did include that as part of the conversation, but we are always willing to, update it and include more information.
Thank you. Yes.
The only other thing I would add, too, with respect to the correctional savings is most of the cost savings would be related to CDCR choosing to move inmates around the prison system. That would make up the lion's share of the prison savings. The savings from the executions also contribute, but most of it's from housing costs.
Presumably, with inmates convicted of murder, there's wherever they are housed, there's going to be the most extreme security measures. In other words, there's going to be a continued cost. They may not all be housed at death row in San Quentin, but there could be an additional costs at any prison where they end up. Is that accurate?
That's correct. Our analysis, our assessment of this is actually very similar to our assessment of the correctional savings that would occur if the death penalty is eliminated, because under both circumstances, it would be up to CDCR to choose if they're going to change the way they handle these inmates. And so under both measures, they could choose to house them under lower security circumstances.
Thank you. Then with respect to the proposed reforms and I think it's fair to say in an effort to expedite appellate proceedings, do you have any sense, do you reach any conclusion as to whether constitutional rights are protected? If this were to pass, would it be subject to constitutional challenge for either abbreviating or limiting current appellate rights? Do you understand the question?
Yes. Yeah. I think that when we say there are a number of questions that need to be answered in terms of how this would be implemented, and depending on how it was implemented, some of those concerns would be there. So to give you an example, one of the things that we mentioned is that delays cannot happen unless there are extraordinary circumstances. There's a question of how what the courts would define as extraordinary. So for example, to the extent that the state could not find competent counsel, and the definition of competent would also be in question, you could see a court defining that as a justifiable reason for delay. So there are a lot of questions there. The other issue in terms of that is how the federal courts will look at this expedited process, one, and then two, the limitations on the habeas corpus petitions that are put into place. And so the federal courts will have their choice in terms of whether or not they feel comfortable with the level of state review that has happened.
Thank you. That's helpful. Related to that, this is hypothetical and maybe not spelled out in the current language of the proposed measure. But if a convicted defendant had not pursued the appellate review as structured, but later, after the 5-year period, exculpatory evidence were discovered by defense counsel, would anything in this proposed measure prohibit that convicted defendant who now has discovered exculpatory evidence from presenting that?
That may be a better question for the proponents, but I believe in my understanding that is one of the circumstances for which an additional petition could come forward.
So that might be under that umbrella of extraordinary circumstances?
So this would be under, there are limits on additional habeas petitions that could be brought forward. And so that would be an exception for an additional habeas petition, because that would be an issue of innocence.
Yeah, there's a couple of circumstances that are laid out. Either if evidence comes to light that the individual hasn't committed the crime or is ineligible for the death penalty, such as the special circumstance didn't obtain, or they're ineligible because of, I think as we discussed earlier, developmentally disabled people are not eligible. So if evidence to that effect came to light, they could also file a successive habeas petition.
Thank you. And as you mentioned, I'm sure the proponents will have some answers to that as well. Thank you, Madam Chair.
Thank you very much. I just have a couple of questions, too. On page 6, the last bullet says the additional layers of required review for habeas corpus petitions should add to the time and cost of each case. My reading of this was that it cut back on the reviews, and that was the point. Am I missing something? What are the additional layers of habeas review?
So right now, under the current system, the habeas petitions are filed directly, they're filed with the Supreme Court. So the Supreme Court makes a decision, and then it goes off to the federal courts. Under this,
really only 2 levels of review under the present habeas system.
Yes. So under the proposed initiative sends the initial filing to the trial court. So you'd start at the trial court would make a decision, and then that could get appealed to the Court of Appeal, and then it could get appealed to the Supreme Court before it went to the federal courts. And so that's where we're saying you're having additional layers of review.
Okay, so you're having certainly increased court workload. Mm-hmm. Okay, and so this is 3 levels of review as opposed to. Now, my understanding is that one of the issues is the inability now for the court to find qualified habeas attorneys to appoint to these cases. In your understanding, is that a financial issue that we would have to, if we were going to hire more habeas attorneys, to do more levels of expedited review, because then there's a 2-year period where the court has to act? Would we be required to increase their compensation?
So I think there are a number of reasons why we have this backlog in terms of awaiting attorney appointment. I think that the proponents would say one issue is potentially the level of attorney qualification, and so the proposed initiative chooses to direct Judicial Council and the Supreme Court to relook at those standards. I think that's one. I think in our conversations with some of the lawyers involved, certainly some of them will say it is a compensation issue. I think that's one aspect. Then I also think that there's this issue in terms of these cases can take a really long time. That's another aspect. And so to the extent that you're an attorney that takes on one of these cases, if they drag on for years, how willing are you to take on the case? I think that's another one. And I think the final one that I would kind of raise that we've heard as an issue is that these types of cases are just very different from what other types of cases that some attorneys have handled. And so that could be an issue that could be handled by training, et cetera. So there are a multitude of different factors that lead into that backlog.
But the training would also have to be at state expense, I would imagine. I mean, you can't require somebody to get training if they don't want to.
Yes. I would say that would be a decision by the legislature in terms of whether to provide the funding. The legislature has a number of choices related to the attorneys. So under this measure, we would need additional attorneys. And so the legislature kind of has the first choice, that's a very big choice, is how the state chooses to handle that. Does the state choose to expand the Habeas Corpus Resource Center and OSP, the Office of the State Public Defender, state entities, and handle it that way? Or does it choose to kind of rely on private counsel? And those are the appellate lists where the courts, that the courts of appeal maintain, as well as the Supreme Court maintains the list. And they have a different kind of compensation structure. It can either be on an hourly rate or it can be on something that's called the fixed fee rate. And so that's a different compensation structure. regardless of that, that's kind of the first step in terms of how you handle it. Then come the questions of level of compensation, the appropriate level, and those are all decisions that the legislature would be making.
But the courts would decide on the lower levels of qualification.
Yes. So the initiative tasks Judicial Council and the Supreme Court with reevaluating and amending. There's a question about to what degree that'll happen, because they are tasked with, one, expanding the pool of eligible attorneys, but two, still ensuring competent representation. And so when Judicial Council and the Supreme Court are deciding that, they could possibly decide that the level of qualifications now are the appropriate level and should remain in place. They could also choose to change it. That's a decision that has to be made. It's one of those factors that will lead into whether or not more attorneys will be available.
Well, if they say that the current level of qualifications is what is constitutionally required or is what should be, what will they do to ensure a large enough pool if there isn't a large enough pool now?
I think that is one of the outstanding issues as part of this initiative. It's one of the uncertainties, the factors. To the extent that the state is unable to have sufficient attorneys, that could be, in the court's decision, a reason for extraordinary and compelling reasons to justify a delay. And so what you could have is you could have cases that are not going through that 5-year period. You wouldn't be hitting those timeframes. Cases would just be taking as long as the court feels it should take.
Okay, so extraordinary circumstances can be interpreted by the courts and by the legislature in a pretty open-ended way?
I would say that it is currently undefined, and I think that there are a number of things that come to mind, such as attorney qualifications, where we think that it could justify a delay.
Okay. Thank you. Are there any other questions?
Leno.
Oh, Senator Leno.
Thank you, Madam Chair. Do you see any constitutional concerns in any of this? And I ask this as a non-attorney, so just wondering, and I recognize if this amends
This just amends
code sections, right? Do you see any constitutional concerns? For example, limiting the number of additional habeas corpus petitions that could be filed? Are there no constitutional protections?
So I would say we are also not the appropriate individuals to kind of weigh in on these issues. I think that they are definitely questions that we had conversations with individuals about, and you can certainly ask the proponents and the opponents. They have different perspectives. We, as part of our fiscal analysis, do recognize that the federal courts may think that those timeframes are not appropriate and may send cases back to the state courts. And so we do incorporate that as part of our analysis as well.
In other words, that's sort of incorporated into the uncertainty. We're not saying that we made the assumption that that would happen. What we're saying is part of the uncertainty about our conclusions is that that could be one outcome.
I think I heard you correctly in answering Senator Monning that CDCR could lower security standards and costs for death row inmates.
And when I said lower security costs, really what I should have said is right now the costs could be lower if these inmates were housed at other prisons. So San Quentin is, as you are well aware, a very old prison. The areas that those inmates are housed in are much more difficult to guard inmates in than more modern designs than the 180-degree, 270-degree cell blocks. So when I said lower security, what I really should have said is lower cost housing arrangements. And what the measure does is say that CDCR has the power to move these inmates around. Currently, statute limits where they can be. And so to the extent CDCR took advantage of that, you could see a situation where you have inmates moved around the state into those lower cost housing units.
So that leads to my next question, which is, Is there anything prohibiting CDCR from doing that now?
Yes,
And
current
the-
statute does.
And what is that statute?
A statute basically limits where these inmates can be housed, generally to San Quentin. Under certain well-defined circumstances, they can go to other prisons, including CSP Sacramento, which is right next door to Folsom. But those provisions haven't typically been used. Usually they're kept at San Quentin. I think in isolated, and I'm obviously speaking about the male inmates, I think in isolated incidences they've occasionally been at Corcoran to receive medical care.
Aside from Corcoran, what are the provisions that could allow them to be moved to Sacramento near Folsom?
Those are basically, I think for disciplinary reasons, they can be moved there. And I think that it pretty much is it. But for the most part, they're always kept at San Quentin, and then in the case of the female inmate, at Chowchilla.
And I realize trying to estimate these potential cost savings or increases are as much art as science. Can you help us, though, in how you reached the tens of millions of dollars? For example, what would be the cost differential between an inmate at San Quentin and an inmate at a newer facility?
Sure. So basically what we did is we took a look at the staffing package that they have on death row and the staffing packages they have around the state for these 180 and 270 cell designs where they typically keep higher level inmates. And we costed out what would happen at San Quentin and what would happen at these other facilities if they were to move the inmates. I think Anita might have the specific numbers, but in general, on death row inmates, the housing cost specifically is around $70,000, whereas in these other facilities, it tends to be lower, about $30,000 and $25,000, I think.
So you're figuring a $40,000 to $50,000 differential.
And it's actually the approach we took here is very similar to the approach we took to the on the measure to eliminate the death penalty, because essentially it would put CDCR in a very similar position, allowing them to no longer single cell inmates at San Quentin and instead move them around the system.